Good morning, everyone. Today will be just a little bit different. You won't see me. I'll be sharing my screen. Just so you know, as we get started today, we are already recording. If you have questions, I know this has been a it always is a really popular Wednesday webinar when we have Disability Rights, Office of Clients' Rights, advocacy here with us. So I know there's a lot of you. There may very well be a lot of questions as well. If you want to type those into the chat, I'll be sharing those with our presenter first. But I just want to make an introduction this morning. So again, good morning, good afternoon, good evening, whatever time it is that you're seeing this. If you're watching the replay, I am sure you all are on our YouTube page or on our video replay where we make these replays available the Friday following the Wednesday webinar. Previously, we were joined by Disability Rights, Maria Salas. A lot of you all may know her, have worked with her during this last year. This morning, I say we are in for a treat because we're going to get answers to a lot of questions that we've had here recently and just over the course of the last year regarding SSI, Supplemental Security Income. So I want to introduce to you all Victoria Virgilio. I hope I'm pronouncing that correctly. You all are more than welcome to do your pandemic clap. We're still in the pandemic. Officially today, we are wearing masks inside again. So keep that in mind, folks. But just don't let your left hand touch your right hand. And welcome, Victoria.
Hi, good morning, everyone. Thank you for that introduction, Melissa. My name is Victoria Virgilio. I'm a client's rights advocate with Office of Clients' Rights Advocacy. It's a pleasure to join this group today and hopefully be able to provide some information regarding supplemental security income or SSI and the appeal process that you're going to find helpful. I appreciate Melissa extending the invitation to attend this webinar series and be able to tap into this forum to, like I said, share information that's hopefully useful to you, connect with you, and also be able to share with you a little bit about OCRA, who we are, and what we do. Before we get started, and Melissa, please let me know if we're ready to go or if you only wanted me to introduce myself and you still needed to cover some housekeeping rules.
No housekeeping, just we're recording and hold your questions until the end. We'll have a Q&A and I will again share those questions with Victoria first, but you're welcome to take it away.
Great, thank you so much, Melissa. So before we get started, I'd like to cover some general information as well and introduce my coworkers. I know there's 3 of my coworkers currently in the call, but just to begin with, I do want to share a disclaimer. Please be aware that Office of Clients' Rights Advocacy, or OCRA, as I'll be referring to throughout this presentation, is a mandated reporter. You know, and as such, we are obligated to report abuse and neglect of adults with disabilities. Also, please note that there's no right of confidentiality in any of the information that's discussed or shared today. So I would ask that you refrain from sharing any private or confidential information during the Q&A session or at any point during this presentation. Lastly, this is a presentation meant for public information only. It is not a private legal consultation and therefore does not create an attorney-client relationship between OCRA and anybody in the audience. As Melissa said, and in the interest of time, to make sure that I'm able to cover the topics that I was asked to address today, I'm going to open the floor for questions at the end of the presentation. However, if I'm unable to get to any of your questions, we're going to provide a contact information also at the end of this training so that you can reach out to our San Diego office, and I will also provide my direct line if you have any questions. Now I'm going to introduce my coworkers. There's 3 of them. who are, one of them might be joining us for the totality of the training, Eulalia, but two of them, Maria Salas and Tanya Schloss, they're going to be joining this presentation briefly. I'm going to give them an opportunity to introduce themselves, but I wanted to mention that Tanya Schloss and Maria Salas, they provide services to San Diego Regional Center consumers. Tanya Schloss is the client's rights advocate for the San Diego office, and Maria is the assistant client's rights advocate for that office. They'll further introduce themselves. Eulalia, she does not cover the San Diego office. Eulalia Hernandez, she's a senior client's rights advocate, but she decided to join our call so she can also help answer questions that I might not be able to answer today. Maria is also going to provide an overview of Office of Clients' Rights Advocacy, what we do and who we are, and then I'm going to dive into the objectives for this training. So Tanya, would you like to introduce yourself?
Hi, Victoria. Thank you so much for that. Yes, good morning, everyone. My name is Tanya Schloss. I'm the attorney with OCRA San Diego office, and I do have a meeting at 10:30, but I still wanted to hop on really quick and just introduce myself. So yeah, happy to be here.
Thank you for that introduction, Tanya. And Eulalia, would you like to introduce yourself?
Yes. Hi, my name is Eulalia Hernandez, and I'm a senior client's rights advocate. And I just wanted to be on to see if I can help in any way. And thank you for having me.
Thank you, Eulalia. All right. So Maria, if you're ready, I think we're ready for you to provide us with that overview of OCRA.
Great, thank you, Victoria. So I've had the opportunity to present the whole what is OCRA to this group, and it's a pleasure to be back today. Today, I'll just give you a refresher on our office, the services that we can provide, and then we'll also have our contact information, as Victoria mentioned. So OCRA is a program of Disability Rights California, and our contract is with the California Department of Developmental Services. And within that contract, our contract states that we're able to provide legal services to anybody who's receiving services from the regional center. So we have 21 regional centers across the state of California. And so we have an office of Clients' Rights Advocacy assigned to each regional center in the state. And so our clients are anybody who's already receiving services from the regional center, or anybody who's looking to start services with the regional center. So those are our clients. And for every office, we have a client's rights advocate. With our office, that would be Tanya Schloss. And then we have an assistant client's rights advocate. That would be my position. And then the services that we provide vary. It's case by case, and we are able to provide information to you. We can review documents or advise on how to resolve your issue. We can help you prepare for upcoming meetings or hearings, assist in preparing documents for you. We provide legal trainings, and we're also able to represent at hearings. And so the areas of law that we work with would be anything from regional center, Lanterman Act, special education, Social Security, Medi-Cal and private insurance, community integration, IHSS, any of those topics are topics that we cover within our office. And I just want to remind everyone that the services are completely free for anybody who's receiving services from the regional center. That's really important because we still have questions as to, how much it is to speak with an attorney or our client's rights advocate. And I just want to make that clear. So we don't charge for any of our services. And I just also want to throw Tanya in here again. She actually specializes in Social Security cases. And so she comes very experienced, and we are in our office, and I don't know if it's just our office, but we get a lot of Social Security cases. And she's been a great resource with our office. And so that's something that our office works with on a daily basis. And so we're happy to help with that. And then in order to receive services with our office, you can either, well, I guess it would be best to call our office. And what we'll do is we'll complete an intake. That means that we will ask you some basic information and then information and details about the issue that you're having to see how we're able to assist. And then the type of service that we provide depends on the issue that you're having. So for every case, we'll evaluate and assess your case and then speak with you and discuss what type of services we're able to provide. And so sometimes it will just be information for you to help you resolve your case. Sometimes it will be providing some advice for you. Sometimes it's technical assistance. Other times we investigate the case and then we can also provide direct representation. But like I said, we'll evaluate all the information and then figure out exactly what we're going to go ahead and help with. And I think that's it for me. Victoria, I think that's all. I'll provide our contact information in the chat. And I think that's it.
Thank you so much for that overview, Maria. And just for the audience to know, if you reach out to our San Diego office, you're likely going to be working with Maria and with Tanya. I've recently worked with them when I was providing coverage for that office, and they're both incredibly knowledgeable. So you're in great hands. I wanted to mention, please know that for accessibility purposes, I'm going to keep the camera off most of the time. You're going to be able to focus your attention only on the slides. So let's go ahead and move into the objectives of this training. Thank you, Melissa. So this presentation is going to provide you with an overview of supplemental security income, or SSI, and that's going to include the types of Social Security benefits, who is eligible for SSI, what you need in order to apply for SSI, what is the appeal process, and then advocacy tips for SSI recipients. Next slide, please. So what is Social Security? What's the Social Security Administration? The United States Social Security Administration is an agency of the federal government. The Social Security is a social insurance program that consists of retirement, disability, and survivor benefits. The Social Security administers a retirement benefit program and 2 disability benefit programs. We're not going to go into great detail about the retirement program, but essentially, in order to qualify for Social Security retirement benefits, workers must be at least 62 years of age and have paid into the system long enough to have earned, I believe it's at least 40 credits towards Social Security benefits, which usually turns out to be about 10 years of employment. And then the amount of the benefit that they receive is based on the worker's lifetime earnings. If you're interested in learning more about Social Security retirement benefits, you can find more information about it on the Social Security website. Like I said, in the interest of time, and because that's not the topic that this group requested to learn about, we're not going to discuss this particular benefit in great detail. Next slide, please. So the Social Security Administration manages 2 programs that provide benefits based on disability or blindness, which are the Social Security Disability Insurance Program, or SSDI, and the Supplemental Security Income, or SSI program. There are 2 types of Social Security Disability Insurance benefits, or SSDI. The first one is for disabled workers who are insured under Social Security. The second is for the disabled adult children of workers who are insured under the Social Security and who, the workers, are either retired, disabled, or deceased. Now, these benefits are often called Title II benefits because Title II is a section of the Social Security Act that covers disability retirement and disability benefits. SSI benefits or supplemental security income benefits are for children and adults who have limited income and resources, because this is a needs-based program. We're going to be talking about limitations on income and resources later on in the presentation. So this benefit, SSI, is for children and adults who have limited income and resources, for persons who are 65 years of age or older, but there are also some limitations in terms of their immigration status. We'll briefly touch on that later on as well. Just for some of you might be aware of this, but the 2021 SSI benefit level in California currently is $954.72 for an aged or disabled person, and $1,598.14 for a couple. Now, if you receive other income, such as SSDI or Title II benefits, which is less than what you're receiving or your child is receiving, if it's less than the SSI standard, you can also get an SSI check to supplement your other income. And the reason this is important is because if you receive even $1 of SSI, you're automatically entitled to Medi-Cal at no cost, or your child is automatically entitled to Medi-Cal at no cost. Next slide, please. So SSDI benefits for disabled workers are benefits for people who have worked and paid or contributed into the Social Security long enough to qualify for benefits when they become disabled. It's important to keep in mind that the spouse and the children of workers with a disability may be eligible for this benefit in addition to the benefits that the workers themselves receive. And then after 24 months of receiving SSDI benefits, the recipient starts getting Medicare. SSDI benefits for the disabled adult children of workers, also known as DAC or Disabled Adult Child Benefit, is a special Title II program for persons who are at least 18 years of age, who became severely disabled prior to the age of 22, and who are unmarried when they apply. So these special dependent benefits draw upon the earning record of the retired disabled or deceased parent that paid into Social Security, right? So essentially, this disabled adult child is tapping into the contributions or the payments that were made by the parent who's now either retired, disabled, or deceased. The disabled adult child will not be eligible for SSDI benefits or DAC benefits until the parent becomes eligible for these benefits. And then after 24 months of receiving this benefit, the DAC recipient is also eligible for Medicare. To qualify either for SSDI or SSI, the individual must meet the definition of disability, which we're going to be talking in greater detail in later slides. Next slide, please. So who's eligible for supplemental security income? In order to be eligible, this is the focus of our presentation today. In order to be eligible for SSI, you have to be either an adult or a child with disabilities, or you need to be or must be blind, or an adult who is 65 years of age or older, who has limited income and resources, and who is a U.S. citizen or national or fall within one of certain categories of alien or immigration status. So essentially, to be eligible for SSI, and this again is the same, applies to SSDI benefits, the person has to either be an adult or a child with disabilities or blind, or an adult who is 65 years of age or older. You also need to meet the limited income and resource criteria, and then there's also some restrictions in terms of citizenship or immigration status. In general, a person who's subject to an active warrant for deportation or removal does not meet the citizenship or alien requirement for SSI eligibility purposes. Now, as I mentioned in the previous slide, to qualify for SSI, the person must also meet the definition of disability. The definition definition of disability for children is a little different than for adults, and we're going to be going over that in a few minutes as well. But to be considered disabled as an adult for SSI and SSDI eligibility purposes, the person must be unable to perform any substantial work due to a physical and or mental condition which has lasted or can be expected to last for a continuous period of 12 months or can be expected to result in death. We're going to be further analyzing the elements of, what qualifies an individual as, as a disabled adult for purposes of SSI and SSDI eligibility. But right now, what you need to keep in mind is the person needs to be unable to perform any substantial work because of a physical and or mental condition, which is expected to last or has lasted for at least 12 months, and that can and that could potentially result in that person's death. Next slide, please. We're not going to go into great details about CAPI. This is a very, or cash assistance program for immigrants. This is a very specific program, and so far I haven't had a case involving this, but it's important. I know that San Diego County, Imperial County has a large Latino community, and within the Latino community, there might be people who, because of their immigration status, do not qualify for SSI. So, we figure that it's important for this information to be out there in case someone in the audience might qualify for this program or know someone who might qualify for this program. So CAPI, or Cash Assistance Program, is a program for immigrants. It's a state-funded program that's designed to provide a monthly cash benefit to immigrants who are aged, blind, and disabled. And when I say immigrants, I mean non-citizens who are ineligible for SSI or supplemental security income only because of their immigration status. I'm sorry, I don't know if I got dropped from the call. I see no, I think I'm fine. So in order to qualify for this cash assistance program, the person has to, first of all, meet the Social Security's definition of disability or blindness, or has to be at least 65 years of age. The person must be a resident of California, and they must be a non-citizen who is either a qualified immigrant, which means that the person is a permanent resident, a refugee, or an asylee, or be permanently residing under color of law, which means that the Department of Homeland Security is aware of this person's presence in the United States, but is not taking steps to deport them. And then the person has to be ineligible for SSI because of their immigration status. So usually it's important to have already applied for SSI to be able to show that the person is ineligible for SSI benefits before they apply for this cash assistance program. We don't, Office of Clients' Rights Advocacy does not practice immigration law, but if anybody has any additional questions about this program, you can reach out to us after this presentation, and we might have attorney referral services, an attorney referral list that we can refer you to for further assistance with this particular benefit. Next slide, please. Now moving on to the definition of disability for SSI and SSDI, for SSI eligibility purposes, we're going to be addressing what the Social Security Administration considers to be a disabled child for purposes of eligibility for SSI. So a child is someone who's under the age of 18, and they're going to be considered to be disabled for Social Security purposes if he or she has a physical and or mental condition. This includes an emotional or learning impairment that can be medically proven, which results in marked and severe functional limitations. We're going to go back to this in a minute, further break down what marked and severe functional limitations mean, in which has lasted or can be expected to last for a continuous period of at least 12 months, or can be expected to result in the child's death. This is similar as with the definition for an adult. Now, that the condition results in marked and severe functional limitations means in practice that it must be shown that the child's condition meets or medically or functionally equates to the requirements of the Social Security disability listing for children. That is, in essence, you would have to show that your child has an impairment or has impairments that are at the same level of severity as impairments that are found in the Social Security's disability listing for children. What a marked limitation means is a serious is a disability that seriously interferes with your child's ability to initiate, sustain, or complete independent tasks. An extreme or severe limitation is a limitation that very seriously interferes with your child's ability to initiate, sustain, or complete independent tasks. There are 6 domains that Social Security looks at in terms, there's 6 domains of functioning that Social Security looks into. The first one has to do with acquiring and using information, which focuses on your child's ability to learn. The second domain has to do with attending and completing tasks, which is the ability to maintain attention, start and finish tasks. The third one involves interacting and relating to others. This focuses on social interactions, essentially. The fourth is moving about and manipulating objects. This has to do with your child's fine motor skills, hand-eye coordination. The fifth one has to do with caring for himself or herself, knowing right from wrong, what type of behaviors are acceptable. And then health and physical well-being. This has to do with the effect of your child's impairment and treatment on your child's ability to function physically. Next slide, please. So how does Social Security define disability for adults? Social Security considers an adult to be disabled for purposes, again, of SSI eligibility if the person is unable to engage in substantial gainful activity. We're going to come back to this concept later on. Because of a medically determinable physical or mental impairment. Medically determinable essentially means that it can be proven by acceptable medical testing and diagnoses, which is expected to last at least 12 months or longer or result in death. In addition to this definition, the individual must be incapable of doing their past work if they had previous employment, or any other work which is available in significant numbers in the area where the individual lives. So we're not looking at, we're looking at jobs that can be easily accessible in the area. But the key test here is not whether the individual would be able to be hired for a job, even whether it be entry level or not, but whether, if hired, the person would be able to keep their job. That is the test, right? That is what being able to engage in substantial gainful activity has to do with. That also is a concept related to the amount of money that a person earns, but being able to engage and sustain this gainful, this substantial gainful activity, right? So the person, what Social Security is looking at is if the person, once they find a job, they're able to hold on to it, or if because of their disability, they are not able to do so. Just one thing to point out, the definition of disability does not include persons who are disabled as a result of current alcohol or other substance abuse. However, the person may still be covered if they meet the disability standard because of other impairments, even if those impairments were the result of past substance abuse. So just something to keep in mind. Now, to be eligible for disability benefits, as we mentioned that SSA, the Social Security Administration, considers an adult to be disabled if they're unable to engage in substantial gainful activity because of a essentially medical condition that's physical or a mental impairment that is expected to last at least 12 months or longer, and that may result in death. So I said that we're going to further break down this concept of substantial gainful activity. So to be eligible for disability benefits, a person must be unable to engage in this concept of substantial gainful activity. A person who is earning more than a certain amount is normally considered or ordinarily considered to be engaging in substantial gainful activity. So it really kind of boils down to a certain amount of money that the person is receiving. The amount of monthly earnings that is considered substantial gainful activity depends on the nature of the person's disability. There's different amounts, whether the person is, the individual is blind or not blind and has other types of disabilities. In this year, 2021, the substantial gainful activity amount, meaning the maximum that this person can earn per month to still meet the eligibility criteria, assuming that the other elements are present, is $2,180 a month if the person is blind, or $1,310 for individuals who are not blind. For 2022, this amount is going to be $2,260 a month for a person who is blind, and $1,350 for individuals who are not blind. Now let's talk a little bit about the application process. Next slide, please. So in preparation for the application, you want to start collecting the records that you see on this slide. Social Security, you want to have your Social Security number handy, or your child's Social Security number handy, birth certificate, proof of income and resources. We're going to further discuss income and resource limitations in future slides for both you and or your child. Any medical records that you have from your or your child's provider, from the regional center, from any specialists that your child sees or that you see, school records, anything that supports, again, the disability, and you want to have this information ready to go, as you're going to be answering these questions when you fill out the application packet. So once you gather these records, you want to start the application process by contacting the Social Security Administration. You can find their number on the website. I can provide it to you guys. We can add it in the chat box. I'm going to add it right now. It's 800-772-1213. And when you contact the Social Security Administration, you want to write down the name of the person that you spoke with and the date when you communicate it with them. And I think this is going to be a good advocacy tip moving forward with any interactions that you have with Social Security, whether it be at the initial application stage, or if at some point you or your child becomes eligible for, or your loved one becomes eligible for benefits, but there's you're finding yourself having to appeal a decision and you need to communicate with Social Security about it. It's always going to be a good advocacy tip, rule of thumb, to write down the name of the person that you spoke with, the date, if you can, the time, and maybe keep a log of the conversation that you had with that individual. Now, coming back to the application process, you're going to be sent an application packet to fill out and return. If the packet, if you return the packet within 60 days of the first phone call, that phone call will be deemed as the date the application starts, it's made. If you need help in filling out the forms, the application forms, and you can't find anybody in your community that can help you with this, you can ask Social Security to assist you. Under Section 504 of the Rehabilitation Act, the Social Security is required to help you or your child or your loved one complete the application packet if you need help because of your disability. So just keep that in mind. And usually their documentation will say this, right, throughout the process. Even if you're dealing with an appeal, it will remind you of this. If your initial application is denied or your child or loved one's initial application is denied, it is important to appeal. We're going to be going over the appeal process later in this presentation, but the reality is that you're more likely to win if you hire an attorney to handle your appeal. As Maria was saying at the beginning of this presentation, we do provide in certain circumstances direct representation, including representation in appeal cases. Whether we're able to provide that level of advocacy on any given case depends on, you know, what our resources are at the time and other factors. But, you know, for the most part, you should be able to hire a private attorney because a private attorney will generally represent at an initial application with an administrative law judge without any advance payment. They will, if they win, assuming they win the case, they will usually collect a fee that's about 25% of the award of retroactive benefits that you or your child or loved one receives. But then if you lose or your loved one loses, then there's no charge associated with that. You can find local attorneys who can help with these type of cases by contacting your local county bar association, but you can also reach out to us and we can provide you an attorney referral list, you know, for the San Diego area. Or if you're somewhere else in the state, we can, you know, we have information. We've collected information on attorneys who can assist with these type of cases and nonprofits that can assist with these type of cases throughout the state of California. Next slide, please. Okay. Now I mentioned that SSI, Supplemental Security Income, is a needs-based program. So what this means is that there's going to be a focus on the applicants or the recipients' income and resources. While the amount of resources or income other than from work does not matter for purposes, for example, of SSDI and D.A.C. Title II programs, because again, SSI is a needs-based program, then the amount of resources and income will matter. Just to break it down, income is money or something that you can convert to money that you receive in a month. So, you know, whatever you've earned in a given month, that's going to be considered your income. If that income is not utilized, then what's left over of that month's income will be counted on the following month as a resource. Now, earned income includes wages, salary, income from self-employment. That's considered earned income. Everything else that's income is considered unearned income. That would be gifts, unemployment benefits, state disability benefits, including Social Security benefits, and all these are all examples of unearned income. Now, it's important to keep in mind that whether it's earned or unearned income, the income that you or your loved one receives can affect the amount of SSI benefits received. Two other concepts that are related to income that's important to keep in mind for SSI eligibility is that, or continued eligibility, is that of in-kind support and maintenance and deeming. So in-kind support and maintenance, or in-kind income, is unearned income because it's not something that you're obtaining through wages or salary, for example. That is in the form of food or shelter. Now let's go back a little bit. Social Security is a benefit that is meant to pay for food and shelter. So the Social Security Administration has a vested interest in knowing if you or your loved one is obtaining these two resources through other means, right? So if it through, a family paying for these things, a family member paying for these things, or donations, they want to know about this. So in-kind support and maintenance essentially happens whenever someone else is paying for or giving you food and shelter. This includes if you're living with someone and you're not paying rent, for example, right? So the best way to avoid having Social Security look at this in-kind amount as, counting against your SSI eligibility in terms of you receiving this as a form of unearned income is to make sure that you or your child or your loved one is paying their fair share for food and shelter. What this means is if there's two of you living in a household and maybe between rent and food, the expenses are, I don't know, $2,000. Well, your fair share of that would be $1,000, right? So as long as you're paying for your fair share, then there should be no in-kind support that's counted against you or your loved one as unearned income that counts against your SSI eligibility or your loved one's SSI eligibility. Now, deeming or deemed income for SSI eligibility, Social Security will take into consideration or deem the income and resources of other people in certain circumstances. So for example, the income and resources of a parent or step parent that lives with a child with a disability is counted as part of that child's income. The income of a spouse that lives in the same household is deemed part of that individual's income. And then in the case of, if we're talking about someone who has a sponsor via their immigration case, then the immigrant sponsor is also considered. Their income is also deemed the income of the person applying for SSI or receiving SSI for purposes of continued eligibility or for eligibility. Next slide, please. Thank you. So we talked about two things being two resources being important in terms of Social Security considering them and looking into them to determine whether an individual is eligible for SSI, because again, it's a needs-based program. So they're going to be looking at income, as we just discussed, but also they're going to be looking at your or your loved one's resources. Now, resources are things that you own, such as cash, bank accounts, stocks, savings, bonds, land, personal property, life insurance, essentially anything that you own that could be converted into cash and used to purchase for food or shelter. These are all things that are deemed resources. If your child is under the age of 18 and lives with you, if they live with just one parent, $2,000 of the parent's total countable resources will not be counted as that child's resources for purposes of SSI eligibility. If the child lives with both parents, then $3,000 of the parent's total countable resources will not count against the child as a resource for the child for SSI eligibility purposes. For SSI, so essentially, the individual can have up to $2,000 in countable resources and still be SSI eligible if all other criteria are met. For the individual, for a couple, it's up to $3,000 in countable resources that they can possess without it counting against them for SSI eligibility purposes. There are certain resources that are exempt from these amounts. For example, a home, your furniture, wedding and engagement rings, a vehicle that's being used for transportation of the individual, a burial trust or account, and then resources that are used for self-support. Also, Social Security does not count as a resource, again, that counts against SSI eligibility, the retirement accounts owned by either the spouse of a person with a disability or the parent of a child with a disability. Another thing that's important to keep in mind in terms of what the Social Security will not count as a resource, and I was recently contacted about this, has to do with retroactive SSI or Social Security benefits. So they will not be counted for up to 9 months after they're received. So, if the person receives a retroactive Social Security, like a back pay from Social Security, they have the first 9 months from receiving them to, essentially spend them down, right? After those initial 9 months, then whatever amount rolls over to the 10th month would be counted as a resource. Now, as I'm talking about, what's counted as a resource and as income, and these amounts might seem very low for some of you, and they are. Just a word of caution. In terms of selling or getting rid of resources, it's important to keep in mind that if a person who either is applying for SSI or who is currently receiving SSI gives away resources or sells them for less than what the resource is worth, they may lose SSI eligibility or benefits for up to 36 months. So, this is just something to keep in mind. I remember a few months ago, someone jokingly said, well, I can just get rid of this property if this is what's preventing me from qualifying for SSI. Well, it wasn't the client, it was someone who was calling for general information about a loved one. And I said, well, you have to keep in mind, and I know that it's a joke, but I felt compelled to mention, the person can be penalized with up to 36 months of not being eligible for benefits if the Social Security feels that they're trying to get rid of property or selling it for less than what the property is worth in order to qualify or continue to qualify for benefits. Okay. Next slide, please. Let's talk a little bit about the reporting requirements for people who are working while receiving SSI. So the law says that if you are working while receiving SSI, you must report your wages. Essentially, you're going to need to report the wages that you make every month to make sure that you are getting the correct amount of SSI, that you're not getting an overpayment, or that this is not going to eventually lead to you losing your SSI. When should you report wages? Well, you need to report your wages as soon as you get your last paycheck for the month. But in general, wages have to be reported by no later than the 10th day of the next month of when you receive the wages. So, for example, if you work in January, you must report wages when you get your last paycheck in January, but by no later than February the 10th, right? So this is important because overpayment issues can be very complex to deal with, and we're going to talk a little bit more about them towards the end of this presentation. But you want to get ahead of that. You don't want to find yourself find your loved one in a position where there might be an overpayment, and now you're having to figure out how to get out of that situation to avoid losing the benefit. Now, in terms of who's responsible for reporting wages, so if you are a representative payee of the individual who is receiving SSI, it's your responsibility to report the wages. You also are responsible for reporting wages if you are a spouse, a parent, or sponsor of a person who is receiving SSI. If your spouse lives with you, same if the parents must live with the child that must be younger than 18. And then in terms of a person who is not a U.S. citizen that's receiving SSI benefits, the sponsor has to report wages if the sponsor, even if the sponsor does not live with the SSI recipient. There's a few ways in which you can report wages. Probably one of the easiest is if you have a My Social Security account set up online, you can report wages that way. You can also report through the Social Security Administration automated phone system. You can use, if you have a smartphone, you can use their app to report, or you can also send, you can report wages by mail. The one issue with reporting wages by mail is that, well, of course, there might be delays involved in when Social Security receives, your whichever format it is that you're reporting wages on. If let's say you're sending a copy of the pay stub, right? If you are sending a copy of the pay stub, you don't want to send originals, right? Because they could get lost in the mail. But if you must send them by mail, then you want to use certified mail, right? You want to make sure that you keep a record of sending a proof of wages and of when you sent it. If you decide that you want to stop by the Social Security office to report wages because maybe you live nearby, you want to make sure that the representative that you speak with will put a stamp on a copy that you want to bring with you of your reporting of wages, so you have a copy and proof of when you reported what you reported, right? So some examples of events that would trigger your reporting requirement would be a change of address, whenever you start or stop working, changes in your income and resources, as we've been talking about. These are all things that you need to report to the Social Security Administration in order to make sure that you remain eligible for the benefit, that you don't accrue an overpayment, right? And that if at some point an overpayment were to happen, that you can establish that it was not because of your failure to report, right? That you were not at fault. And we're going to talk a little bit about that in subsequent slides. Next slide, please. Now let's discuss the mandatory redetermination of SSI eligibility at age 18. All Social Security, Supplemental Security Income recipients who turn 18 years of age, they must have their eligibility reviewed as if they were applying for adult SSI for the first time. The review process is performed because the adult definition of disability in the SSI program is more restrictive than the childhood definition of disability. So it is generally more difficult to be found eligible for SSI as an adult than as a child, even when the individual's medical condition or ability to function has not changed, right? So now the eligibility requirements are more stringent. You need to, or your loved one needs to be reassessed to make sure that now at or past age 18, they still meet eligibility for SSI benefits. Because there's no guarantee that the Social Security benefit will continue into adulthood, it is really important for the individual to prepare for employment, by developing job skills, getting work experience while they're still in school, maybe being connected with the Department of Rehabilitation, right? That's going to be important because, again, there's no guarantee that even if they received SSI benefits as minors, they're going to remain eligible for SSI benefits as adults. If an individual is found ineligible for SSI at the age of 18 redetermination, this decision can be appealed. Now, we're going to be talking about the appeal process a little bit later on, but you're going to see a common theme as we talk about appeals, which is if the appeal is done within 10 days of receiving the notice, then the benefits will continue until the appeal is decided. Now, a word of caution regarding this mandatory redetermination at age 18. If you or your child was receiving SSI benefits, again, as a minor, now went through the SSI, went through the age of 18 redetermination process, and the Social Security determined that they are no longer eligible for the benefit. If you appeal for yourself or your child the decision within the 10 days for these benefits to continue, but then the appeal does not result in your or your child's favor, the payments that were received from the date of the original determination will have to be paid back to Social Security. So just keep that in mind. If the person is deemed ineligible for SSI after the age of 18 redetermination, it is possible for SSI payments to continue for a short period of time under a special provision called Section 301. So the person can be found eligible for continued benefits under this section. For them to be found eligible to continue to receive benefits under this section, they have to be actively participating in an appropriate program of vocational rehabilitation, or they have to be receiving special education services under an IEP or individualized education plan before the disability determination was made. So that would be one way for them to continue for a short period of time to continue to receive their benefits under this provision. And benefits may last until the age of 22 when special education services terminate. Next slide, please. This is just to provide you with a snapshot of the SSI amounts for 2021. So for a single adult who lives independently, the SSI amount is for 2021 $954.72. For a single adult person living in the household of someone else, the amount is $693.58. Remember, the reason this is a lesser amount is because they are living with someone else, so that deeming rule that we were discussing kicks in. For a disabled minor child, the amount is $859.15, and for a disabled minor who lives in the house of another, it's $598.01. Next slide, please. So in terms of how SSI, the SSI amount is calculated, the amount of SSI that you or your loved one receives every month is going to be determined by your or their disability, age, and living situation. This amount is going to be then reduced by any countable income you or your loved one has. Countable income being the amount of income that's left over after paying for all appropriate exclusions. If your countable income or your loved one's countable income is more than you receive, or they receive an SSI benefits, you or they will be ineligible for SSI in the month that you receive that income. So just keep that in mind. And then this process that Social Security uses utilizes for determining income by using your or your loved one's income from a previous month to calculate benefits in the current month is known as retrospective monthly accounting. So for example, your or your loved one's August benefits will determine the monthly benefits for October. Next slide, please. Okay, so we're going to talk a little bit about the appeal process. I briefly introduced that when I was talking about the redetermination at age of 18. I mentioned that if you or your child, upon turning 18 and completing the redetermination, if the person is determined to now be ineligible for SSI benefits, that decision can be appealed. So let's talk a little bit about the appeal process with SSI, or the Social Security Administration, rather. So there are 4 levels of appeal. They're called reconsideration, hearing, appeals council review, and federal court. You can appeal most determinations and decisions that the Social Security Administration makes about whether you can get SSI or about changes to your benefits. You can appeal a Social Security's initial determination on issues that can include, for example, whether or not you're eligible for SSI, the amount of your SSI payment, whether or not you were overpaid or your loved one was overpaid, and whether that amount must be repaid. Every time Social Security makes one of these initial determinations, again, could be whether you're eligible for a benefit, whether they're changing the amount. Every time they make this initial determination, they will send you a notice about it. If you want to appeal the determination made in that notice, then you have to request an appeal in writing within 60 days of the date when you receive the notice. The notice is going to guide you on how to appeal. So it's going to provide information about the appeal process itself. Now, if you file an appeal within 10 days of the date when you receive the notice, assuming that you were already receiving or your loved one was already receiving SSI benefits, these benefits are going to continue until decision is made about the appeal. Now, the next step in the appeal process, and of course, let me backtrack. You're going to receive a notice letting you know what the determination is made at every stage of these appeal levels, right? So let's start with the first one, which is reconsideration. So if you disagree with the initial determination that's made by Social Security about a benefit or the amount of the benefit or overpayment or any other issues that they send a determination on, you can request what is called reconsideration, the first step in the appeals process. You would request this by writing to Social Security, or you can complete a form that's called request for reconsideration, where I did not include many details on these forms in the slide. I think that would be too in depth to be adding information on form, the numbers and the names, but these are the kind of things that you can reach out to our office if you have questions about. We can share the forms with you, or depending on the type of issue, we might be able to provide more direct advocacy. Okay, but this is just like a general overview about the appeal process and the different steps involved. Okay, so back to this first step in the appeal process, that's called reconsideration. So if you disagree with the initial determination made by the Social Security, you can request in writing, you can ask for what's called reconsideration. And you would do so again by submitting a form that's called request for reconsideration. You have to ask for this within the 60 days of the date when you receive the written notice of the initial determination. If you ask for reconsideration in writing within 10 days after you receive the notice, any payments that you or your loved one was already receiving will continue until this stage of the appeals process is resolved. The Social Security is going to send you a notice of the reconsideration determination, and then you're going to decide, if you're satisfied with that resolution, that's the end of this process. If not, you can move on to the next step of the appeals process, which is called a hearing. Now, if you disagree with the reconsideration decision made by Social Security, then you can request a hearing before an administrative law judge, again, by making this request in writing, and there's a form that you would use for this that's called request for hearing by an administrative law judge. So you would want to request this hearing within 60 days after you get the notice of the determination made on the reconsideration process. So you probably see a pattern by now, right? You would want to file the written, you want to file the written request for the appeal at the very least within 60 days of receiving the notice. But if you or your loved one is already receiving a benefit and you want that benefit to continue while whichever stage of the appeals process you're on is being considered and resolved, then you would want to request that stage of the appeal in writing within 10 days of receiving the notice of the resolution of whichever previous stage of the appeal process you were in. So again, if you disagree with the reconsideration determination, you can request a hearing before an administrative law judge. There's a form that you would use for that. That's called request for hearing by an administrative law judge. You would do so in writing within 60 days if you're receiving, if your loved one was already receiving a benefit, and for that benefit to continue, which is called aid paid pending, when you're asking for a benefit to continue while the appeals process is ongoing, then you would submit the request in writing within 10 days. Now, at the hearing stage, you have the right to review, or your loved one has the right to review their file before the hearing. And then you would submit any information about new evidence that you want to present at the hearing stage by no later than 5 business days before the date of the hearing. If you or your loved one does not want to appear at the hearing before an administrative law judge, you can also ask the judge to make a decision based on the evidence in your file. If you were counting on verbal testimony, whether it be yours, that of your child, or witnesses that you bring to the hearing, because maybe the records that were presented are not sufficient to establish the case for SSI eligibility or continued eligibility, that might not be a good option, right? Because you might want to have, your day in court, so to speak, to present these verbal arguments. Now, if you do want to have a hearing before a judge, it's very important that you or your representative, if you're being represented, appear on the day of the hearing, which could be taking place via a video conference call or telephone or in person. Because of COVID, most of these hearings are likely going to be offered via video call or telephone at this time. You are going to receive a notice of the hearing date, the location, and the issue that's going to be decided at this stage of the appeal process, the hearing, within at least 75 days before the hearing. If for whatever reason you or your representative is unable to attend the hearing, it's very important to contact the hearing office in writing about this and explain the reason for not being able to attend the hearing by no later than 5 business days before the date of the hearing. Of course, you want to do it as soon as you know that you're not going to be able to appear, but you want to do so at least within no later than 5 business days, 5 days before the hearing date. The reason this is important is because if you or your representative, if you fail to attend the hearing that's scheduled, you may lose your appeal rights and your benefits. So, as it is the case for every stage of this process, you or your loved one is going to receive a decision, right? A notice with a decision of the resolution. If you're satisfied with the decision made by the administrative law judge, then that's the end of the road for you. If the decision is not satisfactory, then you can move on to the next level of appeal, which is appeals counsel. So you can request an appeal at this level by writing Social Security requesting an appeals counsel review, or by completing a request for review of hearing decision order. It's a form, and again, you can contact our office if you find yourself going through this appeal process, and we can get the forms for you and provide them. Of course, Social Security has to provide these forms to you as well. Just like with the other stages, you have to ask for an appeal. You have to ask for an appeals counsel review within 60 days after you get the hearing decision. The appeals counsel is going to send you a copy of the action that they're going to take. And then that's going to guide your decision as to whether you are satisfied with that resolution, or if you want to move on to the final level of the appeals process, which is you're able to file a civil action with a U.S. District Court in your area if you are dissatisfied with the appeals counsel review. So these are the 3 stages of appeals and in general for all issues pertaining to, we're talking about SSI eligibility. So, whether it be eligibility, continued eligibility, decisions about overpayments and whether they need to be paid. But we are going to talk a little bit more about overpayments, I believe, on the next slide. Yeah. Okay. So an overpayment, I think we are on the previous slide. Melissa, if you don't mind going back to, thank you so much. So overpayments essentially would be if the Social Security Administration would send you or your loved one a notice indicating, that either for a particular time frame, your loved one or you were paid when they had knowledge or information that you had other income or other resources that put you above, either the substantial gainful activity, or that you were overpaid because you were no longer eligible under the disability criteria, for example, and then they continued making payments, right? There are situations where you or your loved one is not at fault, right? Because the Social Security could have made a mistake and made overpayments, or a situation where Social Security might argue that you or your loved one was at fault was if, for example, wages were not properly reported, right? Or were not timely reported. So there are 5 different ways in which you can try to avoid having to repay the Social Security Administration. The first one is called request for reconsideration, which we touched on within the appeal, the stages of the appeal process. Then you have waiver of overpayment recovery or waiver. Appeal and waiver, so you would file for both of these recourses together. Compromise payment and bankruptcy. So let's talk a little bit about when does it make sense for someone to file an appeal in connection specifically with an alleged overpayment of benefits, of SSI benefits. So you would file an appeal if the overpayment notice states that, if the overpayment clearly states your income incorrectly, right? That would be a good reason to file an appeal. It should also be easy to show proof that your income was stated incorrectly. Or the overpayment notice states your benefit amount incorrectly. Again, that should also be easy to prove that it was an error. Or if you don't believe that you owe as much money as the Social Security says that you owe, right? So you may believe that there may have been some overpayment, but not as much as Social Security is alleging that they paid you or they overpaid you. Or you believe that you were not overpaid altogether. Or if you were overpaid, you believe that you're not responsible for the overpayment. That would be, for example, if you are, if you had a representative payee that was responsible for reporting wages, right? Or if you're a child and your parent was supposed to report wages. Now, if you're going to ask for reconsideration for, in the context of an overpayment, we recommend that you ask for an informal conference so that you will have the opportunity to meet with someone from the Social Security Administration to be able to go over the case with you. And if you don't understand why the Social Security says that you were overpaid, then the Social Security representative should be able to explain it to you, right? The same deadlines for appeals connected to overpayment apply. So you still have those 60 days to appeal an overpayment determination. If you miss that deadline, the Social Security may still consider your appeal for good cause. Good cause essentially means that there are some circumstances that Social Security will look at to decide if they're still willing to accept your appeal that was not filed in a timely manner, meaning within those 60 days. So they're going to consider, for example, what were the circumstances that kept you from making your timely request for an appeal, whether the Social Security Administration's actions misled you, meaning that maybe you went to the Social Security office, your local Social Security office, and you spoke with a representative about this and they gave you wrong information about the timeline for when you could appeal, or told you that you didn't need to appeal at all. Whether you were able to understand the timeline for the appeal requirement and how it worked, or whether you, and connected to this is whether you had any physical, mental, educational, or linguistic, like language barrier, any limitations that would have prevented you from understanding and knowing that there was a timeline within which you needed to file the appeal to challenge a determination that you or your loved one was overpaid. So these are things that Social Security will consider in determining whether there was good cause for filing an appeal that was past the 60-day deadline from when the notice was received. Obviously, if you're aware of this, it's always important to file timely, and especially if you want benefits to remain in place, as we discussed this concept of aid paid pending. Again, you would want to file that appeal within 10 days of receiving the notice. Next slide, please. So we talked about the different ways that you could avoid having to repay an alleged overpayment. The first one was requesting reconsideration. We discussed that in the context of the appeals. The second one is a waiver, or waiver of overpayment recovery. A waiver is essentially a recognition that you really have an overpayment, and that you're essentially asking not to have to pay it back. If the Social Security grants your request for a waiver, then you will not have to pay back the overpayment. And if Social Security denies the request for a waiver, that decision can still be appealed. And again, you would follow the same process as explained earlier. Now, it's important to keep in mind that filing a waiver may mean that you are admitting to the overpayment, right? That the overpayment actually exists. So it's advisable to only request a waiver of the overpayment or the alleged overpayment if you agree that you have an overpayment, or you've already lost an appeal challenging the existence of an overpayment, okay? Because again, then you would be essentially saying, Social Security, yes, I've been overpaid, but here's why I should not have to pay it back. Next slide, please. So now talking a little bit about not having to pay it back, right? There's additional steps involved in making this waiver request. So when you're requesting a waiver, you must show that the overpayment was not your fault, and that one of the following circumstances or situations apply. That one, it would be a financial hardship for you to have to pay the money back, because essentially you need the money that you receive to meet your ordinary living expenses. So you're going to have to prepare to submit bills and show, bank statements and any records that will tend to show that your monthly bills are completely or mostly used up by your income, right? So, or that your income, I should say, is, completely used up by your ordinary life expenses, food, shelter, clothing, etc. Or you would have to, if you're still receiving SSI, well, then you would argue that repaying this alleged overpayment would defeat the reason why SSI was established, right? This is true, essentially, if you are still receiving SSI, there's a presumption that, that you're not going to have to pay, you're not going to have to make this, you're not going to have to repay this overpayment. This is especially true when your income does not exceed the maximum supplemental security income and the state supplemental payment plus $85. So if your income or your loved one's income remains within the SSI and state supplemental payment plus $85, then you or your loved one would fall within this like no fault justification for not having to repay the alleged overpayment. The other argument or justification for not having to pay the money back would be that the repayment would be against equity and good conscience. For example, if you relied on your SSI payments and later you found that the payment was incorrect, maybe that you should not have received as much, or that you should not have been eligible for SSI altogether, and you gave up a valuable right, or you changed your position for the worse, relying on that SSI payment. So maybe you declined employment because you were relying on this SSI payment, believing that you were entitled to it or to the totality of that amount, which later turned out to be that you weren't, or that you were not entitled to the full amount, or your loved one was not entitled to the full amount, and you gave up the ability to engaged in maybe substantial gainful activity that would represent that you don't need this SSI income, right? Additionally, if you had excess resources of $50 or less, excess resources meaning you've met the maximum amount that you're allowed to have in resources, and you're only $50 above that maximum amount, and this includes deemed resources, right? So again, your parents' resources, spouses, and so on. And this $50 excess in the limit of resources is the only reason, it's the only thing that has caused your overpayment. Or finally, if the amount of the overpayment is $1,000.01 or less. So essentially, these would be all the reasons that, combined with you explaining that the overpayment was not your fault, is what you would argue to not have to repay that alleged overpayment. Now, you can ask for a waiver for any part of the overpayment. You can also you can request a waiver at any point in the process, right? You can even request a waiver after you've paid back some of the money. And you can, of course, also appeal a denial of a waiver. So if the Social Security decides that the arguments previously mentioned don't apply to you, the justifications, or that you were at fault, and they decide to deny your request for a waiver, you can appeal that decision, right? And again, you have the 60 days to do so from the date of the notice, or the 10 days to continue receiving, payments that you're receiving. So as I mentioned previously, if you are still getting SSI, then the Social Security Administration automatically considers it a hardship for you to have to repay an overpayment, right? Because if you're receiving it and you're eligible for it, they decide that you're still eligible for it, then that means that in this needs-based assessment, it would be a financial hardship to ask you to repay these funds. If you're no longer receiving SSI, because as part of this process, maybe it turns out that Social Security determined you're no longer eligible for SSI, you will need to show that you cannot afford to repay the overpayment based on your income and expenses. Now, looking at the at fault aspect of the waiver, so you would be considered to be at fault in connection with an overpayment when an incorrect payment resulted from one of these situations. For example, you did not report to Social Security info that you should have reported, for example, wages, right? Or resources. You knowingly provided wrong information to the Social Security. So either you denied having resources, you denied receiving certain wages, or you knowingly cashed a duplicate Social Security check. So you received 2 SSI checks and you knew about this and you still cashed both of them. They will also look at whether you have similar overpayments in the past, right? So they're going to kind of look at your track record or your loved one's track record and say, well, in the past, we've gone through an overpayment, a request for a waiver, and this situation has come up again. They're going to consider whether you or your loved one have the ability to recognize, kind of learn and understand what the requirements were for reporting, for example, because this is happening again, right? So they're going to look at that to consider whether you or your loved one is considered to be at fault or not in connection with the overpayment. Another thing that they'll look at is if you received a conditional payment and you did not comply with it. A conditional payment is, excuse me. A conditional payment is an agreement that you or your loved one would sign with the Social Security Administration, agreeing, for example, to repay the administration if you're not able to spend down on a particular month when you were, over income or over resources. But you ask the Social Security Administration to continue to receive the benefit, even though in that particular month, because you were over income or over resources, you would otherwise not have been able to you would have been ineligible for SSI benefits that month, but you entered into this agreement with Social Security saying, by this date, I'm going to spend down my excess income or my excess resources, right? And you did not comply with the agreement. That would be another aspect that, or another situation that Social Security would look into in determining whether you're at fault or not in connection with an overpayment. Next slide, please. So okay. So we talked about, again, in the context of overpayment, we said that there's 5 different ways to try to avoid having to repay the Social Security Administration. We said that the first one is the request for reconsideration, which we addressed in the context of the steps for an appeal. We just talked about the waiver of overpayment recovery, or waiver. And then there's 3 additional ways of trying to avoid having to repay Social Security. One is called appeal and waiver. So essentially both filing an appeal and a waiver. If you're not sure what to do, you want to file the appeal within the 60 days, and then you can ask for a waiver, but the Social Security has to process the appeal first. The second one is a compromise payment. And the last one is bankruptcy. So in a compromise payment, you can offer to pay the Social Security Administration a lesser amount than the total amount that the Social Security is claiming that you owe. So you would be offering essentially to pay less than the full overpayment amount. Of course, the Social Security Administration will consider certain factors in determining whether they should grant this compromise payment. They're going to look at your ability to pay the full amount. They're going to look at what you're offering in terms of a partial payment versus how much you owe. They're going to look at whether this is something that they've offered in the past, right? They're going to look at the cost of litigation. That they're going to consider, well, this person is offering a lesser amount than what they owe in this overpayment, but it would take, it would require X amount in expenses for Social Security to try to collect the full amount via litigation. So they, these are some of the factors that they would look into in deciding whether they are willing to take a lesser payment than the claimed total overpayment amount. And then lastly, the individual that has the overpayment or was found to have been overpaid, they can file for bankruptcy and ask the court to include the SSI overpayment amount as an unsecured debt to be discharged through bankruptcy. Office of Clients' Rights Advocacy does not practice in this area, so you or your loved one would have to consult with someone who specializes in bankruptcy law to address this. And with other areas of law that we briefly touched on today, such as immigration, we might have an attorney referral list that we can provide to you. I know that we have in some areas of law, we might have one in bankruptcy. If you are facing the situation and you're considering that route, you can give us a call and we will provide you with the resources that we have. Okay, next slide, please. So in terms of relief connected to income exemptions, or connected to COVID, I should say, the Social Security is no longer counting most types of pandemic-related financial assistance as income, and this might now be a bit of an outdated slide. But when we're talking about stimulus payment, I don't think that these are still being received, and some of you might correct me. I don't think that's the case, but certainly last year this would have applied. Other type of assistance that could be ongoing because of COVID is unemployment benefits or child tax credits. Those, I believe, I don't have children, so I'm not 100% sure about this, but I believe that the child tax credit essentially just kicked off. So that would be a type of pandemic related financial assistance that the Social Security is no longer counting as income. So good news there. And then lastly, before we move into our Q&A session, just some general advocacy tips when working with Social Security Administration. It's important to keep copies of everything that you provide to the Social Security Administration, especially if you're reporting wages and what you're submitting is pay stubs. You want to submit a copy to them. You don't want to send them your original, right? So in that case, it's the opposite. You're sending them a copy. In general terms, I should say, you don't want to submit originals, right? You want to send them copies. But you want to keep a copy of any communication you have with them, assuming that's something in writing that you can keep a copy of. If you are communicating with them by phone, it's always a good rule of thumb to keep a log of your communications, right? So you want to document who the representative is that you're talking to, when you call them, date and time when you call them, and what the resolution was, or what guidance they provided, right? Because this kind of falls back on when requesting a waiver and determining if, say, a person who has been determined to have been overpaid, whether they were at fault or not, the Social Security will look at what information their own staff provided to the individual, right? So that's where documenting conversations with Social Security is important, because if you took any actions that later affected your rights based on misleading information that was provided by a Social Security representative, if you have a record of when it happened, the time, the date, the name of the person that you spoke with, and what they said, then that's information that you can share, say, at any process in the appeal, to explain why you're not at fault for this, right? Because you maybe were improperly informed about your wage reporting requirements, just to give an example. So important to keep a log of conversations with Social Security. If you're going into an office in person, try to get, bring a copy with you make a copy of what you're sharing with them, and try to get a representative to date stamp the copy. And again, maybe make a notation on the document of the information that they provided, or the conversation, the exchange, right? Also, if you're sending records by fax, we'll keep handing the fax transmittal, right? So you're going to have information about the date, the time, the fax number where you sent these records. So that's proof that you've submitted the records. Now, when I was talking about the different ways in which you can report wages, if I remember correctly, when you create an account with Social Security, I believe you're only able to report one job. So if you have more than one job, you would only be able to report wages, pay stub information for one of them. So you're probably going to have to either send an email or certified mail, or call by phone to report the other income from the second employer. Again, it's important to ask for help if you don't understand the forms, which are mainly in English. So the Social Security should assist you in completing the forms. If you're getting resistance from the Social Security Administration, you can also reach out to us for guidance regarding that. Now, as a tip to avoid future overpayments, it's important to report all changes in your life that can affect the amount of Social Security benefits that you receive, or that you're that may affect your eligibility for the service, right? So it's best to report changes to the Social Security in writing and keep a copy of what you mailed or what you dropped off. Again, if you're dropping off, bring a copy with you, have them date stamp it, maybe get the name of the representative who took the information. And if you report by telephone, same thing that I just mentioned, just keep a log, keep a log, keep a log. So those are my advocacy tips for you guys. And now I can open the forum for any questions that you might have. And thank you so much for listening patiently as I went over this information. Oh, sorry, before I open the floor for questions, I wanted to mention on the last slide, this is our that is our main line for the San Diego office. That's the office where you're gonna connect with Maria Salas and Tanya Schloss. But I also want to give you my direct line in case there's any general questions that come out from this training that may not necessarily lead to a request for assistance that I might be able to answer. Let's see if I can access the chat box, and I'm going to put my direct line there. I just want to emphasize that because Maria and Tanya are the advocates and assistant clients' rights advocate for the San Diego office, if you're seeking assistance with direct assistance from us with a case, you want to call the San Diego office, the number that was on the screen. But I'm going to also provide you with my direct line, which is what I'm putting in the chat box right now, so that if you have if there's a conversation that takes place now during the Q&A and you have any questions like follow-up about that, but not necessarily a case that you want to talk about, then I welcome your contact. And the other thing I wanted to mention too is I just kind of wanted to go back to the disclaimer before we initiate the Q&A session. Just as a reminder, again, Office of Client Rights Advocacy is a mandatory reporter. So any information that's shared, that could be connected to neglect or abuse of an adult with disabilities, we are obligated to report. And also, please, keep in mind that there's no right to privacy in this forum. This is a public training, so please refrain from sharing any names or details if you have a specific situation that you want to discuss today. Okay, thank you so much for your patience, and I welcome questions.
Thank you again, Victoria, Maria, and Eulalia, I believe. I pray that I'm pronouncing it correctly. I just want to thank each of you all for being with us today. Victoria, again, thank you for highly requested information on SSI. We look forward to each and every time Disability Rights joins us for the Wednesday webinar. And it looks like Eulalia did respond to Regina. Regina had a question about, has PTSD been considered a disability for Social Security benefits? And Eulalia's response was, it could be. There is a listing for trauma and or stressor related disorders. And it's a parenthetical 12.15. I don't believe that we have any further questions. We did add Tanya and Maria's information into the chat. I will be sure to post our slides with this information on Friday when I post the replay of the video. If anyone has any other questions, any further questions, feel free to put that into the chat. We'll just give just a couple of minutes.
Melissa, I wanted to add, we might be receiving questions. I just wanted to add briefly, I neglected to include the link to our survey in the last slide. I emailed it to you. If you're able to share it with the audience today, we would love to hear from them, because it's a way for me to know how I can improve, and how we as an organization can improve, and what services they if for the people in the public who might be aware of OCRA and may have ideas of ways in which we can improve as an organization, we welcome that. So if they're able to complete the survey, I would greatly appreciate it.
Sure, we can send it out to those who registered and make that available above the replay link. If you want to drop it into the chat, feel free to drop it into the chat as well, for those that are attending live. Let's see. I don't see any more questions coming through. I do want to be mindful of everyone's time. We generally end any time between 11:40 and 12. So just thank you all to everyone who joined us today. The survey link is listed in the chat, and that will also be above the replay video along with the slides. So thank you to everyone. I know we're not all on cam this morning, but thank you for being with us. And this is our final Wednesday webinar for the year 2021. I'm excited to have disability rights to come back again in 2022. We're looking forward to it. Don't forget, you all should be receiving here your invitation, your save the date for our spring in-person event, Saturday, May 14th. That's May 14th, 2022. It's going to be from 10 to 2 a.m. at Martin Luther King Jr. Park on Skyline Drive. Keep your eyes peeled for that invite and that save the date. If you know an organization that should be joining us and be represented there that day, feel free to forward to them and they can grab a vendor table as well. All right, we will see you all back next year. Y'all have a blessed rest of the day. Thank you again to Disability Rights California, Office of Clients' Rights Advocacy. We'll see y'all next year.
Thank you so much, Melissa, and we'll be more than happy to come back next year. Happy holidays to everyone. Thank you for your time.
Bye-bye.
Bye-bye.